I will hand it over to Tom briefly just to describe how we will be conducting the webinar, which is how we do all our webinars, but I just want to be clear. So Tom, I'll hand it over to you and I'll take it right back after that. Are you still muted, Tom?
Yeah, that's fine. That's fine. Thank you. Thanks, Scott. I just wanted to say thank you to everybody for joining us here on Facebook and also on Zoom. So we're just going to ask everyone, if you have a question, either in the Zoom meeting or on Facebook Live that we're monitoring also, write that question in the chat or write that question in the comment section. And after Joanne finishes her beginning presentation, then we're going to go ahead and answer those questions or get those questions addressed as they came in. So we're looking forward to an amazing seminar and talk this morning. And again, if you have any questions, write them in the chat and we'll be happy to get to them at the end. Thanks, Scott.
Okay, thank you, Tom. I'll be brief, though I could go on forever. Joanne Seminara is not only my good friend, she herself is an amazing political leader. And this morning she's going to be wearing her hat as an attorney she's a partner with, one of the most well thought of elder law and general practice firms in Brooklyn, Grimaldi and Young. And she's an expert and has written significantly on how important it is for you to have your affairs in order in terms of estate planning. And I don't have to tell people that after what we've been through during the last 3 months and hearing horror stories about people that did not have wills, the consequences of not being prepared for life-threatening illness or death are very severe in our country. So, Joanne, we're just so happy to have you here this morning, and I'm very proud to call you a friend.
Thank you, Scott. And thank you to the Scott Klein team at Compass for inviting me to speak today. I really appreciate the invitation and the ability to further communicate with people about how important planning is. I've worked with you on many deals. I know the kind of quality and care that you take with each client, with each deal. You're relentless in pursuing positive goals for your clients. And whenever I partner with you, I really feel secure. It's all going to work out well, and it always does. So, I'm just proud to have this relationship with you as a friend and as a team, because I know each individual player of your team member delivers the same expert service that you do, and that's just incredible. So thank you for inviting me to speak today. So what are we talking about? We're talking about a subject that people really don't like to address. They would rather avoid for the most part. So I really want to try to make clear, as Scott introduced, how critical it is for people to have plans in place, both while they're alive and so that their assets can pass and they can fulfill their legacy as a person with the least amount of stress and strain on their loved ones and the least amount of needless expense and delay. So I could tell you one story after another, and I'll lead with this one, which is a recent one that came to me about 2 weeks ago in this very horrific age of COVID. Unfortunately, people are being lost who never even thought they were in a category of being at risk. We're all at risk, let's face it. Some of us are at more risk than others. So I got a call. Of course, I mix up the names and the facts just so no one can be identified. But I got a call from Bill, a man in his early 50s. He had just lost his partner of 25 years, Suzanne, unexpectedly. They've been living together for 25 years. They're as much a couple as any other couple that you'd ever want to meet. Suzanne owned their home. She was always going to get around to it. She was going to put his name on the deed. She always told him, this is your home. It will always be your home. No question about it. And they lived as much as together as any married couple did and would. Suzanne has no children. She really passed away unexpectedly. She got a cough. She ended up in the hospital. And he's in terrific, terrific shock with his loved ones around him. They're both US citizens, but most of her family is abroad in Mexico. Parents, brothers and sisters. And now this potential client doesn't know where to turn, because he is afraid he's going to be ousted from the home that he's put together with his cherished partner for so many years. He's calling me in a panic. He has no rights. He wants to be the administrator of an estate that doesn't have a will. And he has no rights to that. He has no rights to be appointed administrator. First in line are two aging parents. One of them has dementia, they're separated, and siblings in another country. Yeah, he thinks he has a good relationship with them, but he doesn't know how this is going to shake out. He would like to administer the estate in New York. He doesn't know if he'll be able to. There's other money that he wants to have access to that Suzanne wanted him to have. He is incredibly distraught. His life, he's been robbed of his partner, his loved one, and now he doesn't know if he's going to be able to live in the home that has been his home for 25 years. No planning. Someone dies at age 51. They never expected it to happen. So I'm getting calls like these. I got a call last week from a woman who is dying. She said, look, I don't know how many days I have. Maybe I have a week. How fast can you help me? We had a Zoom call. I'm doing the power of attorney, the healthcare proxy. I'm going over there on her front step, probably by the end of this week, and try to get whatever I can get signed. She has 6 brothers and sisters. She's single. She's survived by a 91-year-old mother. Her assets are going to 91-year-old mom. That's not what she wants to happen. She doesn't want to divide her home in 7 different shares among her brothers and sisters. She told me what she wants. And I don't know if I can get it done fast enough, but I am certainly going to try. I'm getting call after call like this. None of us ever predicted a pandemic. But putting that aside, I see case after case where delay and inability to face these issues causes terrific expense, waste, sometimes destruction of property. So Scott and his team are familiar with this particular matter. A gentleman lived in a home, owned 2 properties in Brooklyn. Both of them were not really cared for. He died unexpectedly. Doesn't have a spouse. He doesn't have children. His sister lives in a faraway city. He passes away. She doesn't know what to do first. Is there a will? Isn't there a will? Is there a safe deposit box? Where do we begin? We decide there's no will. We decide that half the house he's living in belonged to his father. His father just died 20 years ago. That estate was never handled. So now we got 2 estates backed up with 2 pieces of real estate to manage, to get through probate court, not probate court, administration court, surrogates court, with no will. We don't even know who the petitioner is going to be because he didn't tell us who he wanted an executor to be. It's going to be the sister. There's only a sister. But this case is going to take about 1.5 years. Now with COVID on top of it, every time we get a contract to sell real estate, we've got to go back to the court and ask permission to sell a piece of real estate under a specific contract. The waste is enormous. The property's empty. Somebody's paying the real estate taxes, the water sewer bills for 1 year or more until this property sells. It could have been simple if this gentleman, I'll call him John, had gone to an attorney and did even a simple will. It could have been a lot simpler if he did a trust, but he just didn't do it for whatever reason. And I think what people don't appreciate is that the failure to plan, it's not just something I don't want to deal with. In some way, it's a selfish act, because if we think about it and we think about what our values are, and maybe our values are we want to leave our assets to a charity that deals with social justice, or providing food to people who need food, or any of the things we care about, animal rights, you name it. Our failure to plan deprives the people and the causes that we love of the funds as soon as they can get them. And maybe it puts those assets at risk so that we're just going to spend assets before we decide what this pot of money or real estate looks like. We can sign contracts for real estate. We can button it up with the lawyers and get it all done. But in many cases, we're dependent on the courts when there's no clear plan, we got a contract, and that 6 months that it takes to get permission from the court may kill the deal. And we've seen that. We've seen that. If we could have done this deal quickly within a normal frame of 2 months, 2.5 months, it would have been done. But we're stopped. We're stopped by the failure to plan. And that failure to plan is costly, it's stressful, and it just builds stress among family members. When there's a big family, we got somebody looking at it, you know, people are looking at each other saying, why didn't you get mom to do this? Why did it turn out this way? And all the squabbles of a lifetime somehow make their way to bubble up. Those are the bad stories. But there's so many good ones. And the good ones are where mom or dad plans and they make it clear to the kids what the plan is. Most importantly, they make clear who's in charge. Who's going to be my executor? And let me just put this on the table with you, kids. I'm going to choose Sammy. I'm not going to choose Ryan. Maybe Ryan's going to be the healthcare proxy agent. Maybe we can find a job for everybody. But if you as a person make clear who you want to be in charge, you already eliminated a whole bunch of squabbling, because now without a will, we don't have to fight about that issue. I recently, in the last few years, represented a man who owned 7 pieces of real estate in Brooklyn and did his own will and named his daughter as the executor. And she died before him. And then we had 5 other siblings to argue about who was going to administrate that estate, while I had 7 buildings and hundreds of tenants at risk because nobody was in charge. No one was there to pay the real property managers, to pay the real estate taxes, to pay the insurance. I can't put tenants at risk. I'm running to court with an emergency order because I don't have a will with a named executor. Because someone said, oh, I'll just name myself as executor or my daughter, and I'll not put down 2 substitutes. You always need alternates in these documents, which is why I urge people, even people who have done planning, every few years, or if you have a major life event, if you lose that loved one you've named as executor, you got to look back and say, okay, now where are we now? Do I need to amend this document? Do I need to consider, I mean, when I was younger, I put my sister as my executor. Now my kids are almost 40, and now they're the executors. Why? My sister's my age. I need to think forward and keep the plan moving so that when the time comes, it works. And that reduces stress on my loved ones and my family and your loved ones and your family. So you kind of get the idea. What I want to talk about is advanced directives. And maybe now more than ever, you need to be very clear about documents like a healthcare proxy, a durable power of attorney, a living will, and so on. So let me just give you some definitions. A power of attorney, a well-drafted, beautifully notarized power of attorney is a thing of beauty because it appoints an agent that you trust will do the right thing for your loved ones and for you while you are alive regarding paying your bills, paying your rent, paying your co-op maintenance, paying your fuel bills for your apartment, for your house, paying your real estate taxes. Something happens to you and you're single and you have no one who's on that checkbook or no one who can transfer those assets. And you end up in the hospital for 3 months. Well, what happens? Does the bottom fall out because you can't pay your bills or open your mail? Your power of attorney agent can do all of that for you and more. So it's really critical. And there's so much more. A power of attorney, as you know, gentlemen and Danielle, because you go to real estate closings, a properly executed power of attorney can make or break a closing if a seller cannot be present. If they're out of the country, if they're sick, if they're out of state, you got a date you got to close by for an important reason, you got a mortgage commitment that's about to expire, they can't make it, their spouse is sick, you name it. I got a power of attorney. Someone can give it to me. That's not what I prefer. I prefer for each person who has one person in their life that they trust, preferably who's good with money and executive decision making and not going to let it all fall by the wayside. Put that person as your agent on your power of attorney. If you get a long-term illness and you have to transfer assets to qualify for Medicaid because you're looking at 24-hour care, we can look at that power of attorney and say, yeah, we can help here. We can help preserve something for this family and not spend this money or this asset down with liens for Medicaid and long-term care, because we have this beautiful thing called this power of attorney with all the proper powers stuffed into it. I call it the kitchen sink power of attorney. We, as a practice in elder law and doing a lot of real estate, make sure that every bell and whistle that we can think of, and we're always adding more powers because we don't know the future of our clients. You know, we didn't know there was going to be a pandemic. So it's really important to have someone who can put your shoes on and go to the bank, go to a real estate closing, apply for Medicaid, change beneficiaries on life insurance policies in case the person you named died before you, then you're hanging. They can do this for you if it's enumerated in that power of attorney. And I've done amazing work with properly executed powers of attorney for people that are no longer competent. I have re-engineered their estate plan according to how they want it done, and they can't get it done because between the time they came to see me and the time I prepared the document, they were unable to execute those planning documents, like a trust, like a deed. So it's really, really critical. As critical, if not more critical, is the healthcare proxy. So the healthcare proxy is a document signed by anyone in the presence of two witnesses that names an agent to make healthcare decisions for you if you cannot make them yourself. Not if you can make them, because you have the right to your own bodily decision making. But if you can't make them, if even temporarily in a coma, under surgery, serious decisions near the end of life, and you know your loved one is merely suffering near the end of his life or her life, and she would not have chosen just to suffer for a couple more weeks, you can take that power of attorney, go to the hospital, go see the doctor, the care provider, and say, look, I have this document. I am the one who will make these decisions. I have been appointed, and I know my loved one's wishes. Incredibly important to choose not one person, but number one, alternate number two, alternate number one, alternate number two. Why not? If you have people that love you, who will do the right thing, who know you and know your values, talk to them about it. Get that document done. Names, addresses, telephone numbers, email addresses if you'd like. Two disinterested witnesses signing it, and you have that protection under you for decision making. A companion document is called a living will, which is a document that states, if this is your wish, that you do not wish to be kept alive by extraordinary means, if your death is imminent and there's no reasonable expectation of your recovery. Those documents go together with one more document called a HIPAA release, which says my agent, doctor, hospital, can see all my medical records because I trust them that much. They have to make these decisions. They have to have the information with which to make those decisions. There's more, of course, but I wanted to focus on those two because they're so critical. Durable power of attorney. Durable means it survives my incompetency. Durable power of attorney, it's a statutory form. The statutory form is not adequate. It needs more powers added to it. The healthcare proxy, someone to make decisions for you if you cannot make them yourself, with two backups. A living will, something you should consider if you believe that there may come a point when they shouldn't just keep you alive at all costs, and you should be allowed to die naturally with pain relief, but no further intervention. You know, many of us, you know, this is human life. We respect one another. We respect ourselves and our loved ones enough to say, this is what happens if I get sick. I don't want you scrambling, arguing with your sister, discussing who loves mom best and who's going to make this decision or not. I'm going to tell you, Johnny, because you are a nurse practitioner, that you are the best person to make these decisions for me. I'm going to tell Sam, because I know he's good with money, that he'll be my power of attorney agent. And then I'm going to have a will or a trust that says, who's going to be my executor? Who's going to be my trustee? Who's going to get my assets? How they're going to be distributed? Maybe You have another child or friend that needs a further trust, because if you leave them $100,000, they're going to blow it and not be able to use it for their own welfare. Maybe they'll just squander it. Maybe they're vulnerable to other people. Maybe they have a disability and they're on Medicaid. We can deal with all those issues and preserve your burning desire, if you think long enough about it, to favor the people that you love or the causes that you love by getting it down on paper in a way that can be enforced, made clear, and quickly administrated, so whatever you leave behind can get to those people and or causes that desperately may need it. Why spend years in courts? Why leave things unclear? Why have real estate lie fallow and maybe be subject to vandalism or lawsuits while it's sitting there waiting to be sold? Delay increases risk. Delay increases expense. And I think everyone would agree those are not good things. And it certainly increases stress on the people that we love and rely on the most to take care of our affairs. It is stressful enough when someone is ill and someone you care about, you know, you may lose them, and then to have to deal with a mess behind it is really a lot more than any one of us should have to go through. So my goal and my passion about this is putting people in order, making sure I understand what they own, how they own it. Is it joint with somebody else? Because if it's joint with somebody else and the somebody else survives you, it's going to that person outside your will, right? But there's always the risk that that somebody else may not survive you, like my executor in that will situation where he only appointed one executor. So when we look at a plan, we want to know what you own, how you own it, where you want it to go, who's going to be in charge. The idea is it should go smoothly. We need to reduce stress. And we have to make sure that the legacy that you want to leave for your lifetime of service and work goes the way that you envision it. And frankly, if enough people gave it enough thought, and we could change a lot about how things work in this city and this state and this country if people gave more thought to those decisions, because we can do a lot of good with what we leave behind and avoid a lot of attorney's costs and even taxes if we're very thoughtful about it. So
Hey, Joanne.
that's what I do. I think maybe we're winding down. Is that fair? Or should
Well, actually, Tom, let me just mention, I wanted to thank both Stephen Nelson and Daniela for, helping prepare this webinar, and you as well. And I'll let the three of you ask any questions of Joanne, because we've have a few that are coming into the chat.
Right, Joanne, so we had some questions come in both on Facebook and also here on the Zoom. So I'm going to go ahead and just read them off as they came in. The first question was, what happens to debts when someone passes? So you've got a lot of credit card debt or a mortgage debt. What happens?
Well, what happens is that those debts, those valid debts, let's assume they're valid, right? They get paid off first. So a debt must be paid off by the estate, and it is the responsibility of the executor or the administrator to investigate those debts, make sure they're valid, and if they're valid, to pay them off. If there's not enough money in the estate to pay the debts, well, then they can't be paid. It's not anybody else's primary responsibility unless they're primary on the account, like a credit card account. But so it often takes time, as I talked about the delays. Many times they're Medicaid nursing home charges that I'm getting calls for. Well, I didn't get paid for the last 2 months of his death. I say, I'm sorry, but it's going to be 1.5 years before we even learn who's going to be appointed or what the assets are actually collected, so we can consider that debt. But it is the responsibility of the estate representative to pay the valid debts of a decedent. Some of the debts aren't valid, and some of the debts, need to be looked at to see if they're truly debts or whether there's a defense against the debt. And so we look at each debt very carefully to make sure that it does have to be paid. But if it is valid, it's off the top. And a credit card company or a debtor can easily file a notice of claim in surrogate's court to make sure their debt is recorded against the estate.
Okay, thank you so much. So
You're
the
welcome.
next one here that we have here is about power of attorney. And it says, can power of attorney be anyone in your life? And how do you change who is in your power of attorney. And what's interesting, so I actually have these documents myself, and I know that before we got on, we were talking about how uncomfortable these conversations can be when you're talking to a relative or a friend and say, hey, I need you to be able to make these decisions for me should something happen. So is there a kind of hierarchy that you would recommend if you're looking at the person that's going to be that power for you?
Well, that's a conversation I always have with my client. If it's not obvious to them who the person should be, and sometimes the obvious person is not the right person. Sometimes it's not your spouse, because you might know that if something happens to you, he or she is going to fall apart and really not be able to function on an emotional level. It's someone who obviously is of impeccable honesty first, right? Someone who can be trusted with your assets and to honor your estate plan, because if they're dishonest, you're very vulnerable. They can take assets out of your estate illegally and fraudulently. It's someone who's not going to put off making decisions, who's not going to let your bills lie fallow. It's someone kind of who looks like they have their life in order and their stuff together, because if they're sloppy and don't keep records, that puts them at risk in terms of someone else questioning what they're doing for you. So it's got to be someone who is good with money, will keep a record of how they act for you. You should keep a ledger, an accounting of sorts. If you're going to start signing checks and doing finances for people, you want to protect yourself, but you always want to be able to show that you've done it, you've done it well and you've done it, and you're not putting your loved one at risk. So it's really a matter of skill and trust. It's also a matter of proximity, because you don't want to choose your cousin in Norway who's not on the ground and can't be there to determine when you have this need, and might not be able to observe the fact that you haven't paid your maintenance for 2 days, or you're not really talking straight for a few days and something's going on. You want it to be someone who is relatively in your life on a regular basis, so they can pick up the slack if things start to get difficult for you.
Okay, great, thank you.
Joanne, I had a question.
We've got two more that I'm gonna reverse the order in which these came in. Through Facebook, we got a question that said, does where you live or pass away influence what happens with your will? Example, if you New York versus Connecticut, or California versus Texas.
Well, a will goes to the court or is probated in the county in which you reside at the time of your death. So if you reside in Kings County, but for the last 3 months you've been living in Palm Beach, your will be probated in Kings County. So where the probate happens depends on where you reside. Now, people who move from state to state, let's say you lived in Brooklyn for 20 years and then you decide to move to Kentucky, you're very well advised to take your Brooklyn will and go to see if your new residence, a Kentucky lawyer who practices in this field, to say, could you take a look at my will and let me know if this will is valid in Kentucky? Because wills are a creature of state law. A lot of these documents, most of them, all of them, are creatures of state law. Healthcare proxies are a little more flexible because they're kind of obvious. Powers of attorney are state law documents. When you change your personal residence, you're always best advised to take those documents to a local attorney who's qualified in the state in which you move and make sure they can still fly there. Powers of attorney probably have to be done over. Wills may have to be done over. Florida rules are a little different. Some states need 3 witnesses, New York needs 2 witnesses, etc. When you die in one state and you have property in another state, particularly real estate, you will usually have to do what's called a second will probate in the state outside the state in which you resided, because that's usually the law, and that's 2 probates. And if you're in that condition, if you have that fact pattern with real estate in different states, you are well advised to consider doing a trust so you don't have 2 probates. Trusts can avoid probate. I don't think we have enough time to talk about trusts, but there's different things you can do to protect that delay and extra work.
All right, thank you. And so in our last question, I'm just going to check the stream, make sure if we did get one more come in. So let's go ahead and address the one that came in first. Irene questioned the fact that wills are state law. Can you briefly explain how wills are a matter of state law?
Well, every state has a surrogates or a probate code that details the requirements for making a valid will. And so obviously I don't know all the requirements of all the states, but most of them say they have to be signed in the presence of 1, 2, or 3 witnesses who are disinterested. All of them say, I'm sure, that the witnesses have to witness the signer signing. Some of the states say you have to say certain things before you sign the will. You have to get the testator or the person making the will to acknowledge that it is their will, that they have read it, that they understand it. That many states require an affidavit to be attached to the will to say that the witnesses understood that the person understood what they were doing and wasn't under duress and could read and write English, or if they're blind, that the will was read to them. All those laws are state specific. They go through our state legislatures, they get passed, they get changed. During this COVID crisis, us attorneys were clamoring for changes to some of those laws because we had clients that wanted to make wills that couldn't get to a notary. We couldn't meet with them. We couldn't get witnesses on location. We couldn't even meet with our own clients. So now, due to some state legislation, which has been repeated, I'm sure, in many other states, we can actually do remote signings of wills and deeds and other documents. And if we follow all the rules, and there are many, we can notarize those documents remotely, and we can have witnesses sign remotely. It's really an amazing power. It was needed, and the state legislature did get it together very quickly. It's state law. If I'm in New Jersey, I gotta go see what that state did to make sure that my will is valid. I know the New York laws because I'm primarily a New York attorney.
John, I had the last question that just came into, which I kind of feel a little bit as well. What kind of advice do you have for kind of the reverse of initiating estate planning? Let's say it's children having conversations with aging parents, and maybe they've never spoken about what's going to happen, but again, their time is kind of coming, kind of broaching that conversation.
So I think when you speak to a parent in a loving family, you want to say that, Mom, you know how much I love you, and my brother and I care for you. We want to make sure that you get the best care possible as you age. And the only way we can really ensure that is if you release some of that responsibility to make sure that you get that care to us. Mm-hmm. Because we're here to help you. But in order to help you, we need tools. And if we don't have the tools and you're not able to make decisions, we want to be able to do the best for you. We want you to be alive. We want you to have the best possible life possible. We don't want you to spend all that hard-earned money that you saved and that we know you want to go to your grandchildren for their education. Mm-hmm. These are things that you've always valued. So let us, out of our love for you, out of the fact that we have our own lives and our own families, and obviously we want to be able to act as quickly as possible if a stressful situation arises. We want to be able to be there for you so we can care for you in the best possible way. I think you want to make it positive. I think you want to say, I need those documents too. I'm 30, I'm 35, I'm 40, and I'm getting them done because I have clients who things happen to them really tragically when they're young. And if they don't have the documents, it's just so much more difficult. All of us have the same blood running through our veins, and we all have to care for each other. It's a matter of care. It's a matter of stress, and it's a matter of family harmony. Who do you want to make these decisions? Yeah. And sometimes it's good to say, what happened to Aunt Susie? Aunt Susie ended up in the nursing home. They spent $300,000 caring for her. Sometimes you can look outside at another example. Sometimes you can, put a book in front of them. Sometimes you can point to an article and say, just read this, and when you're ready, we'll talk about it. But the situation happens over and over again, and we're just trying to make sure that we're going to be there to help you when the time comes.
Yeah. That's really
great.
It's not magic, but it's coming from a place of care and love.
Yeah.
Well, that was great, Joanne. I just wanted to say, Paul, Danielle, and I just closed on a house with another partner in Joanne's firm that had been in the same family for over 100 years. And the mother never wrote a will. And it took years and years for this to go through the surrogate system, years upon years. And again, to sort of emphasize what Joanne said, this is not the way it has to be. And these were uncomfortable conversations. No one wants to talk about being sick or dying. But I think if the last 3 months teach us anything, this is something we all need to be prepared for. And it's tragic enough for someone to be incapacitated or to leave us, but to add another layer of that, of all this confusion and dysfunction, that could be avoided, is totally unnecessary. So if you have any more questions for Joanne, you can email us at the Scott Klein team at Compass, and we will get them to her.
Sure.
And thank you so much for helping us this morning. I just wish everyone a good Sunday, and let's be vigilant in making sure our country moves forward in a just direction. So
Thank you. Thank
Thank
you all.
you,
Thank you,
everyone.
Scott. Thank you, team.
Thank you,
I
Joanne.
appreciate
you.
the opportunity to be with you again. Bye.
Take care.
okay, bye-bye.
Bye.
Bye.